The following is a paid program. Advice and opinions expressed on the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands. Welcome in, everybody, to Taking Care of Business. Of course, I already said Melick Law, so you know Rob Melick's the guy we got sitting in with us today. Rob, before we dive into all the stuff that you do, I got to take a moment to ask you. I know you're a Brewers fan.
Yeah.
This weekend was pretty solid for them.
Yeah.
I'm assuming you were watching.
Oh, yeah. They clinched, which is good. As much of a foregone conclusion as that was, it feels nice to be a mathematical certainty at this point.
Absolutely. I just got done seeing, and I'm glad I saw it after the morning show and before this show, but I saw a clip of them reading a letter in the locker room from Euchre.
I heard about that.
And, I had to recompose myself before I could come out here and do anything.
Sure.
And I imagine being a longtime Brewers fan, you understand what that means to the team. But, as a big fan, what does it mean to you to see them in this position?
I mean, it's just great. It's one of those things where you wish Uke was around to still see it, but, depending on what your faith and spirituality are, maybe he's watching from above. I mean, it's just one of those things where it's kind of hard to deny that possibility. I mean, right. This is a team that was not projected to do very much, and they're getting a lot of career years from guys who either weren't supposed to have career years yet, or maybe
right.
Their best years were behind them, and they're having a second coming here, so to speak. So it's just been a fun season. So I have one more game I'm going to, the fan appreciation game on the 27th. So
very nice.
They always give away a lot of cool prizes, and it's always a free ticket giveaway that they have at the end of the game. So, it's one of those things where I've gone the past couple of years. Sometimes there's been conflicts and everything, but
right.
With the way this game's going on a Saturday night, like I said, my two sons play football. One plays Friday nights, the other one plays Saturday morning. So won't have to miss any kids' sporting events. Wouldn't be willing to do that, but as long as I have the ability to get to that game, we're going to go, so it'll be fun.
Well, there you go. Obviously, dedicated dad, father, of course, dedicated Brewers fan, and dedicated to the work you do, which let's dive into that a little bit, because when we bring you on and we talk with you, what we're talking about is some conversations that might be a little bit harder sometimes, a little bit more difficult to have, conversations that it's better to have now than when it's too late. And we talk about, depending on your spirituality, faith, whatever, where people, there's a lot of probabilities and thoughts and things. This is stuff that's guaranteed. Yeah. We're not getting out of this alive.
No, like I said, unless until they invent an immortality pill, the mortality rate remains at 100% for the human race. So we're all going to need this at some point. And I get it. It's one of those things where first generation lawyer, they didn't teach you this stuff in law school, but it's one of those things where I guess I underestimated the disparity between how people view death and dying. I have some people like myself who just view it as an inevitability. Let's be prepared for it. Let's do what we can. And then I have some other clients who break down in the office crying when they talk about these kind of issues. And obviously my job is to be professional. My job is to explain the pros and cons, but to be sensitive too. I mean, I'm a human being after all too, right? I'm not a robot. I have roles beyond being a lawyer. I'm a father, I'm a son, I'm a husband, I'm a brother. I have different roles, in my everyday non-attorney life. And so I get it. I understand that spectrum there. But at the same time, regardless of what your opinions are on it, it's going to happen. And again, why not be prepared for it? And that's really what I help people with, is just kind of getting over that initial hurdle. Because again, compared to other areas of the law, I call a lot of areas of the law need-based, right? You're not going to seek out a criminal defense attorney unless you've been accused of a crime.
Right.
You're not going to seek out a divorce attorney unless you're contemplating a divorce, right? There's a certain event that occurs in life that triggers the need to get to that type of attorney. And that's very common. Personal injury, same thing. Whereas with estate planning, the whole word of planning means that you're doing so in anticipation of an event that will happen. Not an event that could happen, an event that will happen. Like I said, not everybody gets a divorce. Not everybody gets charged of a crime. Every single one of us is going to pass away. So like you mentioned before, a lot of times people do it when it's too late. And dying without an estate plan in Wisconsin can be very expensive. It can oftentimes lead to having assets go where you don't want them to go, having the government get involved when they don't need to be involved. So that's the main crux of my job, is to first and foremost give people the information that, I always try to explain to clients that when it comes to decisions, there's always pros and cons. And one of the things people need to know is, what are the pros and cons of doing nothing? Because that's the approach a lot of my clients take. Now, by definition, if I'm meeting with somebody, it means they are doing something, but perhaps people listening to this or watching this are deciding whether to do anything about it. A common refrain I hear, when I'm at events like county fair, things like that.
Right.
Is, well, yeah, I know I'm going to die, but it'll just go to my kids. It's no problem, And well, you got to understand how it's going to get to the kids. It's going to have to go through probate to get to the kids. Right. That's going to be time consuming. That's going to be expensive. So just having that conversation, explaining to people why they're better off with an estate plan versus without an estate plan is really kind of the first step. And to help facilitate that, obviously I do shows like this, but I also offer free initial consultations. And that applies whether you're listening to this program or watching this program or not. Anybody, I always offer a free initial consultation because, again, I don't want the cost of an initial meeting to be the reason why people put this off, right, or that they just ignore it and do what I call the ostrich burying its head in the sand type thing, right? Let's get information. Let's get full and complete information so you can make informed decisions. Because it doesn't matter what the area is. I mean, obviously my area is estate planning, but it could be anything. It could be auto repair. It could be maintenance, whatever the case is. The idea is that if you don't have full and complete information, you can't possibly make a fully informed decision. So at my firm, I offer those free initial consultations, chance to meet with me, talk about your specific situation. I can throw up some options. I can explain pros and cons of either doing something or not doing something. And that way, at least you have the solace of knowing you made a fully informed decision.
And I mean, that's kind of a huge deal too, because that means if maybe they think, okay, I really do want to do something, but for whatever reason, I don't know why this would be the case, but I just don't vibe with Rob. Mm-hmm. At least they've got some information that they can take with them and make a good decision. If they do vibe with you, maybe they're thinking, yeah, I like what you're saying, but currently I've got, no kids, I'm not married, whatever. It's just me, myself, and I, and so I don't need a big deal. But then maybe you will need, life changes, life happens.
Absolutely. Well, and just breaking those down into two parts. I mean, yeah, I get it. I'm a human being. There's people who don't get along with me. I mean,
I don't imagine who, but
well, it is what it is. I mean, we have interpersonal things. I do my best to try to relate to people on any level I can. But if that happens, meet with another attorney. At least you have full information. You have full and complete information. I mean, the example I always give is this is how I dress when I meet with clients. Some clients have an expectation I'm going to wear a suit and tie, and that's just not me. So if you want an attorney who's going to wear a suit and tie, that there's plenty of them out there. Best of luck to you. And there's no hard feelings about that. Again, there's plenty of fish in the sea, as I like to say. When it comes to estate planning clients and things like that, if we after that initial consult, like you said, you use the word vibe. We don't vibe well, fine. At least you know. But as far as that second part, you're right. Life needs do change. And really some of the main events in life would be marriage, children, and home ownership. I mean, those are really the three kind of events that would cause people who start out with the I'm single, I'm over the age of 18, because again, if you're under 18, it doesn't matter. We can't do an estate plan for you anyway. Right. But you're over 18, you're single, you go from that to perhaps getting married, perhaps having children, maybe not necessarily in that order, but then owning a home. Again, perhaps not necessarily in that same order either. But those are really kind of the three main triggers that I look at as an estate planning attorney to say, gee, let's look at what we had before. Let's look at what we might need to have now in light of these life changes and see if we can plan accordingly. And at my firm, I guess two comments on that. One would be, it is very common for me to meet with people at various stages in their lives. For instance, that, let's pick your arbitrary age, 24, 25. They're single, they have a job, they just got out of school, out of the military, whatever the case is. Well, that person over the age of 18 does not need a full-blown trust. Maybe doesn't even need a will. But having basic powers of attorney is necessary, because if they become incompetent, if they lose capacity, nobody makes those decisions, not even parents, unless we have a power of attorney. Well, next life event occurs, you're married. Well, now you're married. There's other issues. Now you have two of you. Usually, when you get married, you want your spouse to be the person making those decisions. I'd question whether you'd want to get married if you weren't inclined to have your spouse be the one making those decisions. Usually, at least early on in the marriage, right? I mean, at the honeymoon stage, right? But then having children is another issue too. And people say, well, what does having children have to do with it? My kids are just get the money. Maybe. But guardianship is the issue there. And again, I'm just kind of hitting on some highlights here. We could certainly talk about these more in depth, but that is a life event that would occur. And again, if you have children under the age of 18 and you don't have an estate plan, courts are going to determine guardianship of those minor children. Nothing we can do about it. People are like, well, what about a notarized letter? What about a videotape statement? Completely unenforceable. They have to be in either a will or a trust. And then I talk about home ownership. Home ownership is usually the trigger that gets people over the $50,000 probate threshold. And that's where we may want to consider upgrading from a will to a trust to get the guarantee of probate avoidance. And that's really the main thing that I try to do for most of my clients. Because, let's face it, I can talk till I'm blue in the phase. Most 18 and plus year olds, let's say from 18 to 24, they're not going to rush out and call me and say, "Oh, I need an estate plan based on this."
Right.
It's not reality. I'm going to give you the information. I'm going to explain the pros and cons, but I've been doing this long enough to know that the phones aren't going to be ringing off the hook with 18-year-olds calling, "I need these documents," right? Where it really typically more comes into play, the majority of my clients are the ones who are at or approaching retirement. And those are the people who start thinking, gee, this is really the time I need to get it in place. I mean, obviously it's better to get it in place earlier. You have that peace of mind for longer, but just the practicalities of it, the majority, if I had to say the average age of my client, I'd say early to mid 50s. It should be a lot younger than that, but it is what it is. So, and those are the people who we really need to talk about probate avoidance and make sure we have an estate plan that'll guarantee that we avoid probate and the costs, the time, the aggravation that comes with having to go through probate, as well as the publicity and the government involvement. I mean, a lot of my clients want to do it privately, and a trust allows you to do it privately, whereas most, or it's certainly possible, if you have a will, the estate will go to probate if you don't have a trust. So the trust creates the guarantee of probate avoidance, which is why I'm a fan of trust-based planning. But a will's better than nothing, and I tell my clients that all the time. If your options are do nothing versus create a will, absolutely a will allow you to determine where assets go. It may not be the most efficient way to get them to the people you want them to get to, but at least it'll get there. But then the trust really does go a step further in getting that guarantee of probate avoidance.
Now, I do want to remind people, if you want to call into the show, if you have a question that you'd like to ask, maybe it's something that can't be answered super in depth, but maybe some general answers might be available to you. Now's a great time to do so. You can give us a call here, 920-885-4446, or you can call or text us at 920-887-9595. I know we have Jeff on standby up there, as always, ready to take those texts and those calls and send them our way. Thank you for that, Jeff. I'm gonna jump back a little bit because you mentioned your roles. Your father, your son, husband, all that. We all have roles that we, in life.
Sure.
The minute you're born, you're automatically, somebody's kid. When you have kids, you become somebody's parent. When you get married, you become somebody's spouse. If you go through these life changes, sometimes with those roles comes a level of responsibility. And that responsibility is super important. When we think about as parents, I think about my kids and my responsibility to them. And there's some things that are easy. Like I can say, oh, well, my kid's on my insurance so they reach a certain age, whatever, that's fine. But then I think about my oldest child, and my oldest child is going to be 20 this year. For more than, a year now, going on 2, they've been outside of my realm of control for a lot.
Sure.
And we've talked about this a little bit before, but this is one of those things that's been kind of the biggest eye-opener for me when it comes to thinking about why not waiting until you're older might be a good idea, and that is that power of attorney bit. Because I know, from talking with you, something happens with her partner doesn't get to know what's going on because they're not in a marriage or have any power of attorney or agreement there. I don't get to know what's going on. That's a very scary situation for a parent.
Absolutely. And what I would say is you're correct about everything you said except for one minor thing.
What's that?
It wouldn't matter if they were married. You mentioned your daughter has a partner.
Right.
Okay. Obviously, I can imply or I can infer that they're not married at this point
Correct.
in time. Even if they were married, spouses still don't automatically have that right.
I mean, that's even scarier.
It is. Oh, for sure. Well, and to all the married people out there, most people would think, well, gee, it's my spouse. Of course I can find that out. Now, without a power of attorney, you can't. And again, I give this example all the time. For those who don't know, my main office is in Saukville. Saukville's about an hour and 10, depending on how fast I'm going on 33, away from here, right? Yep. So it's basically due east of here. But again, let's just say I'm in a car accident. Majority of Highway 33 between here and Saukville is 55 mile an hour with 2 yellow lines in the middle. Right. So someone has a stroke, someone has a heart attack, somebody's texting and driving, whatever the case is. They cross a double yellow, hit me head on. I'm taken to the hospital. I'm in a coma. If I'm in a coma, my wife not only can't make medical decisions for me without a power of attorney, she can't even receive information regarding my care, prognosis, or condition, because sharing that information without my consent, which I can't give if I'm in a coma, violates my HIPAA rights. So again, if that's the set of scenario, right? If I'm in that same car accident and I break my leg, I have capacity. I'm in a lot of pain, but I have a lot of capacity to say, hey, here's my wife's number. Give her a call. Tell me where I'm at. That's different. But if I'm in that car accident, let's face it, if someone crosses a double yellow line at 55, I'm probably not doing very good at that point. I'm probably if I'm lucky, I'm in a coma. I might be dead at that point, right? But again, the hospitals can't just assume that the spouse would, or that the person in the hospital would want their spouse to know that information. I mean, let's face some facts here. 52% of marriages end in divorce. Mm-hmm. There are a lot of people, I'm sure, who are married for perhaps religious reasons, perhaps money reasons, perhaps for children reasons, societal reasons, whatever the case is, that they wouldn't want their spouse to be the one that was informed. And it exposes the hospital and its staff to significant liability if they share that information without that patient's consent with someone for whom the patient would not want it shared. So again, at that point in time, the only way to avoid that, even for a married couple, is to have powers of attorney, let alone someone who's not married. Because let's face it, most people, and again, I'm casting a broad net here clearly, because there's always exceptions for sure. But let's just say arbitrarily between the ages of 18 and 22, customary college ages, let's say. Okay, I'd say the overwhelming majority of people in that group, if they were in that situation, would want their parents being the first people to make those decisions. Certainly not everybody. I mean, I have clients who are married in their late teens and early 20s, and I have people who are in the military, whatever the case is. They're really close to an older sibling, whatever the case is. The point is that those people cannot make those. The moment that child turns 18, parents lose the ability to make those medical and financial decisions unless there is a power of attorney in place. And what gets even scarier in that regard is just, again, the lack of information. Most people in Wisconsin, let's say, the day they turn 18, they are still in high school.
Yeah, that is right. That for me, my entire senior year.
Certainly not all of them, right? And like I said, for me, I graduated high school at 17 because I have a July birthday. So I have a later birthday. The actual day of my high school graduation, yes, I was 17. So my parents could still make decisions. But that July came around and I was about to go off to college, then they couldn't. So the idea is that I would think most people who aren't listening to this program, who aren't aware of estate planning laws, would just assume, hey, my kid's a senior in high school. My kid is living under my roof. You mentioned earlier, my kid is on my insurance plan. Of course I can make those decisions. Of course I can receive that information. No, you can't, not unless you have a power of attorney. So again, I encourage anybody over the age of 18 to have those powers of attorney, because we're all one moment away from incapacity. See, and that's the difference. We talked about earlier the inevitability of death, and certainly that is the case. Fortunately, incapacity is not a given. And in fact, incapacity is very rare. But as I like to say, I love numbers, I love statistics, probably why I love baseball so much. It's not a 0% chance either. Right? Any given 18-year-old has a point something chance of being in that situation. And we're not going to know whether you're in that 0.01 who has it or the 99.9 who doesn't. So that's why we have those powers of attorney in place, to make sure that if we are in that minority of people who lose capacity once they reach the age of 18, we as parents can make those decisions, because it does happen. It happens every single day. And the most common way is car accidents, but it doesn't even have to be a car accident. It could be anything.
I'm going to ask you the question that I know I've heard asked before, and you've probably gotten this question before. Well, my husband carries a piece of paper in his wallet that says, if anything happens to me, call my wife. Or my kids have something in their bag that says, if anything happens, call my parents. Is that even legally binding? Can the hospital see that and go, oh yeah, this is fine?
No, the answer is it's not legally binding whatsoever. But what I will say is that only medical professionals are subject to HIPAA. Okay, so in other words, if there's a word that I'm looking for, Good Samaritan, that was the phrase I was looking for. If a Good Samaritan comes on the scene and looks and sees that, certainly that Good Samaritan could reach out to the parents. A first responder, if it's an EMS or EMT, they cannot, but a police officer could. Again, they're not subject to HIPAA. But my thing is, why rely on that? Why take the chance on that? Why not create those powers of attorney to guarantee that the medical providers can share that information? Because let's face it, yeah, there'll probably be police officers and maybe firefighters and people on the scene. Maybe there's some witnesses, maybe there's whatever. That's possible, but that's not the most important part. I'd argue the most important part is when they get to the hospital and the medical staffs have the ability to diagnose and take a look at the situation. That information cannot be shared. So again, why not have those powers of attorney in place? It is a very simple, relatively inexpensive thing to create, and they can be changed over time. I mean, whenever I meet with an 18-ish year old client of mine, I will make sure that they and their parents know, look, these are temporary in terms of who you want. I mean, they last as long as you want, but let's just say you have that, 18-year-old going off to college, and yeah, they want their parents on there, but maybe in a couple of years they find that significant other, and now they want that significant other to make the decisions. Great, no problem. You can adjust the documents and put that person in place. It could always be updated, always be modified, because that's an issue that a lot of the 18-year-olds have. And I was 18 once too. I get it.
We're all there, yeah.
you want autonomy, fast cars and freedom, right? That's what you want at that age. But the idea is that you also want to know that if something really bad did happen, at least in my case, I would want my parents to know, and I would want my parents to make those decisions. Until I met my wife when I was 20. She wasn't my wife at 20, but the point is that at that point in time, it was a serious relationship, saw where it was potentially going. So having the ability to make those changes, if I did, because again, first generation lawyer, I didn't have any of that, but I'm saying, you bet. But I'm saying if I had, or if my dad had known about that, then I would have said, look, at a certain point here in time, we're engaged. I want my fiance on there, right? I mean, that's certainly possible. Let alone marriage. I mean, that kind of changes everything there, but. The point is it has that flexibility. The point is life events do occur. Things we can't control are going to occur. Every single one of us who's still alive has a life to live out. The script can flip, positives, negatives, tragedies, surprises. We just don't know. The point is that at least at my firm, not only can those changes be made on all of those documents, but at my firm, I don't charge for those revisions. So if you create a set of estate planning documents with me and those life events do occur, changes are done on a complimentary basis. So again, you have that built-in awareness that the documents can be updated at no charge.
Now, obviously, when we talk about, and you kind of brought this up a little bit earlier, when we talk about the inevitable life event that's going to make some of these documents kick in. We're not going to talk about power of attorney now, but we're moving into that will and that trust stuff. That inevitable life event that makes those kick in and take effect is obviously the passing of an individual.
Yes.
Regardless of how you handle it, I like to handle it with humor because that's just me. I also make the joke all the time, I'm going to live forever or die trying. So far, I haven't failed. Chances are I will. Get to work, scientists. I could use that immortality pill. But it's at that point that these things kick in, and it's at that point that things become real serious. People are already dealing with a lot at that time. If you lose a loved one, your family's left behind. And I start thinking about it in the sense of, if I'm the one that's going, do I want my wife to be worried about what happens to her, what happens to the house, who's responsible for paying off what money goes where? Do I want to put that stress on her? Half the time, I don't want to put the stress on her in choosing where we go to dinner, let alone all that other stuff.
You bet.
And that's kind of what you're doing here is you're helping to take a lot of that stress out. And you're making things a little bit easier and more palatable for people who are having to go through what is, and oftentimes, a very traumatic life event.
That's right. And what I've learned, again, 18 years of practice, people grieve differently. They process it differently. It's just a function of who they are. And a lot of times it's a function of the manner in which somebody passes away. All things being equal, we're going to be at a time where someone passes away suddenly. We're going to take that in a much more difficult way than if somebody has cancer and has been fighting cancer for a year and a half. Right. It doesn't make the passing any more or less tragic, but you have the ability to process it. And in some ways, you want the person to end their suffering. If whatever the case is, if they're going through a particularly difficult end of life and whatnot, it's almost a blessing that they pass away. You still miss the memories, you still have those memories, but it's just a different way of looking at it. But again, I do help people with that. I guess the one piece of advice I would give here is not legal advice. Okay, this is more practical advice. It's one of those things where it just has surprised me how frequently what I'm about to say happens in the 18 years I've been practicing. Please don't call your estate planning attorney the day your relative passes away. I get that so many times. I've had it within the hour. People will call me. And my advice is, look, I express my condolences. Grieve. There are more important things to do at this point in time. Rest assured that the documents are done properly. Because as a practical matter, I can't even help people to have a death certificate anyway.
Right.
I can't just verbally go off a call from a kid or a spouse saying my wife or my mother, my father died. I need the death certificate from a legal perspective before I can do anything anyway. Right. But just the practical advice there would be to grieve. Take time. Like I said, wait till we get a death certificate and then we can start talking about the business end. But that's exactly what it is. I have taken that part off the table, and I have had countless opportunities in my practice where people have said that to me. They said, look, because mom and dad did what they did with you prior to their passing, it made everything so much easier. We could grieve. We could take the time and reflect and not have to be nervous about how the home would pass or anything along those lines. So that's really one of the most rewarding things in my practice. And I do tell my clients that when it comes to estate planning, you're not necessarily planning for yourself, you're planning for your loved ones. And looking at it through that perspective oftentimes will encourage people to actually get motivated to do it but it's true. It's not as though I'm trying to coerce people into doing this type of work, but it's 100% true. You're not going to be around to see your estate plan by definition. but your children will be. Your spouse may be. Well, your children may be. They may not be. But somebody is going to be around to make sure that the plan goes the way it's going to go. And I do think that helps a lot of people kind of come to grips with the idea of going through this. But, I had mentioned earlier, and you just mentioned now, the idea of the immortality pill.
Right.
And what I find interesting is it's a bit of a sidebar. Would you take it? If you knew that there was a pill out there that would give you immortality, would you take the pill? Because I don't know if I would.
I mean, that's a really good philosophical question.
It is.
There's, is there a I change my mind pill to follow if because I mean, there's so much good in the world, so much I'd love to enjoy and partake in, but at the same time, I think there's probably a good reason why we all have an eventual number that we're going to hit.
I do too. It's one of those things where it's like, you could really dig deep into this. Like, what's my physical condition?
Right.
Am I how I am now, or am I how I would be at 85? There's limitations in terms of what you can do. Do you run out of money? Like, does everyone else have access to this immortality pill? Because if I outlived if I was the only one who had the ability to take it and outlived all my loved ones, outlived all my friends, like, what am I doing here?
Right.
So there's a lot to that, but I find that question fascinating from just a pure, like you said, philosophical standpoint, as opposed to legal one. But again, I don't think that one's in the near future. So
I don't believe they're working on it necessarily, but if it does come up, you and I will sit down, we'll discuss together if we should take it.
You bet.
Now that being said, when it comes to things like the trust-based planning, we've talked about before, that's designed to outlive you. And, depending on how it's built and what it could maybe not be immortal, but it can go for a very, very long time because they don't die. They just run out of money.
Well, they run out of money, or they run out of the ability to pay the money. I mean, what ends up happening is, I'll just give you an example with my trust, right? I have the two boys who are 15 and 13. My wife and I die tomorrow. Okay. That trust is going to be open a lot longer than if, let's say, we pass in 35, 40 years, right? 40 years, the two boys will be 55 and 53 at that point in time.
Right.
They just get the money, very easy. Now, on the other hand, a middle ground position could make it even last longer. Let's say the boys are 35 and 33 when they pass away, and one of the boys also passes away with me, but has a 2-year-old child. Well, now the trust is going to be open for a long time because that 2-year-old grandchild in this case is now going to be receiving his or her deceased father's share under the trust. Right. So I get that question a lot. How long does this trust have to be open? Long enough to have the assets be dispersed in accordance with the terms. Right. Because again, my trust, boys don't get access to money until they're 30. So you're already looking at 17 years there potentially. Right. Or they may decide to go to private schools and use the down payment for a house, in which case it could be depleted a lot quicker. Or one kid could decide to do that. The other kid could join the military and get on a GI Bill and do all that. And his share is going to last a lot longer than the other ones, right? We just don't know is the point. So I do get the question a lot. There's no statutory period of time of liquidation. It's just, again, if the trust has served its purpose, it's distributed the money, or there's simply not any money to disperse based upon life events and everything else.
But it is good to know that that's doing exactly what it's supposed to do. It's supposed to outlive you, and it's supposed to disperse stuff out. We talked about one of the other benefits of trust-based planning being the avoidance of probate. Yep. And we've talked about probate a little bit before, but one of the things I wanted to touch on and talk about a little bit more, you mentioned, is the privacy of it all. We've mentioned if you have a will, you go to probate, that is something it's in the court publications, it becomes public knowledge, that information is all out there. So if you're leaving, let's just say, 50% of your estate to one kid, 30% to another, and 20% to, a charitable organization, everybody knows that.
You bet.
Everybody knows what your kids got. Everybody knows what organization got what. And that opens them up to who knows, any ne'er-do-wells or otherwise who want to talk to them. Whereas with the trust-based planning, that's all kind of sealed away.
It's all private. No, and that's exactly right. And especially at a younger age. I mean, if the public knew that my 15 and 13-year-old sons were going to be receiving some money through an estate, again, maybe there's a predator out there. Maybe there's a gold digger out there. I mean, there's any number of issues that could come up or can be avoided by maintaining that kind of privacy. So to me, that's one of the most underrated aspects of probate avoidance. I mean, the cost and the time, they are what they are. Average cost of probate in a state is about $8 to $12,000. Right. Average length of probate is 12 to 18 months. Those are miserable. We should look to avoid them. But privacy is an underrated aspect of another benefit of probate avoidance. So it's one that I try to emphasize just as much as the other two.
Now, that privacy doesn't just extend, and I'm going to touch on the privacy here in the sense of if somebody comes to you and says, hey, I want to set up a will, if somebody comes to you and says, I want to set up a power of attorney, I want to set up a trust-based. There's also a level of privacy of what you do. That lawyer-client thing still holds.
Attorney-client privilege extends beyond death, and that's just one thing that's important to know there. Now, again, from a trust standpoint, if you're appointing somebody as a trustee, then I do have the ability to talk to that person as a trustee. But as far as what they may have told me prior to death, no, that retains the attorney-client privilege even beyond death. So, and again, it's important to have that privilege. It's important for people to be able to speak candidly with their lawyers. I mean, it's like a patient-physician privilege or a penitent preacher privilege. I mean, these are important things. We want candor. We want people to be honest. We want people to be able to feel that they can share that information without that professional or religious figure sharing that information. So that's something I take very seriously in my practice, and every attorney should take very seriously. So, that's definitely something that's can be considered private between the client and the attorney for sure.
We talked about some of the cons to probate, one being the cost, the other one being the length of time. 12 to 18 months seems to me like 12 to 18 months of potentially dealing with, family bantering, trying to figure out, what's paying for what while we get this all figured out, who's covering what, and then really kind of seems like it stretches out that whole mourning period because you're just thinking about and working through that for 12 to 18 months. It almost seems like it's a no-brainer to make the step up, but there's got to be reasons why people don't necessarily make that jump.
Yeah, I think there's a couple of reasons, and I think it depends on the attorney that you're working with. But I'd say generally the main reason is a lack of information on the benefits of a trust. I think when a lot of people viscerally hear the word trust, they think extensive wealth and passing on generate trust fund. I mean, you hear that, and I think that kind of initial thought process turns some people off to creating a trust. So I think that's one thing. I think the other thing that people don't understand is just how bad probate is. And so, again, if you've had, I get a lot of clients who come to me, if I had no other previous relationship, hey, my sister died, my brother died, had to go through probate as a disaster. What can we do to avoid it? And the other thing is trust-based planning is more expensive than will-based planning. But the analogy I draw there is this. A car is more expensive than a bicycle. But most people don't buy a bicycle to putt around town in, right? They buy the car. Why do they buy the car even though it's significantly more expensive? Well, it's more convenient. It's less effort. It saves time. There's any number of reasons. And so, too, is the difference between will and trust-based planning. So, again, to me, it starts with a conversation. It starts with each person's individual circumstances, having that conversation to say, all right, again, a will is better than nothing. Just like if your options are biking around town versus walking around town, most people are going to choose the bike. But when the option is bike versus vehicle, most people choose the vehicle at that point.
I recently learned that my wife's grandmother, when her and her husband were married, and of course they still remain married, he's just gone now, but when they were both alive and together, they had a will-based setup, and it wasn't until his passing that she started to see that there were some holes in things as far as power of attorney and control, and she went in and tried to get the will changed, and there's a lot of weird wording, and somebody actually luckily made the suggestion of, hey, now's a good time to look into that trust base.
Sure.
She was getting up there advanced age. She's still around now, but, it's been a huge peace of mind for that whole side of the family because that was already, a headache. But this is something where, people can come to you later in life. Like you said, the average age is in the 50s. But people can definitely come to you as they're approaching retirement. Is there a point where it's obviously death would be the ultimate too late, but is there a point where it's too late to start having those conversations? And is there a grace period before things like this kick in?
There's no grace period unless we're talking about irrevocable trust, which I'm not a big fan of. I don't do too many of them. But assuming we're talking about revocable trust, there is no grace period. But there is one time period prior to death, and that's capacity. If they don't have capacity, I can't execute documents. So if somebody, and I get this situation, unfortunately, too commonly, it probably happens a couple times a year, but the idea would be an adult child, let's say a child in their 50s will call in, mom or dad is in their 80s. They just got admitted to a nursing home. They just got admitted to a memory care facility. We need to get these documents done. My first thing is I need to determine capacity. If I can, and again, I'm not a doctor, but again, as human beings, even without medical degrees, we can assess capacity, at least to some extent. I said, look, I'll happily visit. But if we can't establish capacity, we're done. I can't do anything there. So it is a little bit prior to death. I mean, depending on the manner in which somebody dies. I mean, if I get in a car accident on the way home, I'm dead. I never had a period of incapacity, but a lot of people will experience a period of incapacity before they pass away. It's pretty common, actually. So that would be the other thing. But again, as you know, my trademark slogan, "Before you die, call this guy," obviously it does not apply to incapacity. Incapacity is kind of implied, and I couldn't find a word to rhyme with incapacitated. So it's just, maybe for the next trademark. But it's just one of those things where that is kind of the straw. But again, what I always tell my clients is having that peace of mind for as long as possible. Why not have that peace of mind for as long as possible? Let's face it, fees and expenses are only going to go up. And my profession is no different than any other. Fees go up, prices go up. It happens all the time. And so why not have it for as long as possible? Because, again, we're dealing with an event that we know will happen. But we have no idea when it's going to happen.
Right. And I got to give you props and a bunch of respect for the fact that you just said, like, hey, you're gonna check into capacity. You're gonna help make that determination. Because sometimes when we think of lawyers, we don't always think of them in the best light, and we get this mindset of they're just the shark is the term that's often used.
Ambulance chaser. I've heard them all. Like I said, sure first generation lawyer. I've heard every lawyer joke. And I'm a big. I don't know if I ever told you. I'm a big Simpsons fan. I don't know if you like the Simpsons.
Yeah.
But, Lionel Hutz, how he's portrayed on the Simpsons. The bumbling idiot, unscrupulous attorney. And then that's just that's what we have to overcome here, sir. And I do what I can to try to transcend that.
One of my favorite bits or pieces, clips of him is there's the truth. And the truth.
Exactly.
And it's like, oh, yeah, gotcha. But that's showing. I mean, obviously, you're dealing with stuff that's very sensitive. You're dealing with very sensitive times in people's lives. And, capacity is super important because if they can't knowledgeably agree to what they're agreeing to, that's a whole other can of worms that can be opened up legally.
Absolutely.
I want to dive a little bit more into the details that can come up in estate planning, because one of the things I hear people say is, oh, but it's got to be so complicated because I got to know everything I own, and I got to know what everything is worth, and I got to know, who am I going to leave this to, but if they're not around, who gets it after that, and if they're not around, who gets it after that, and I got to have all this long and drawn out different. Does it have to be that bad?
Not at all. And again, I have a lot of clients who will say to me after the fact, wow, that was painless. That was a lot easier than I thought it was going to be. And again, obviously I can't comment on how other attorneys run their practices, but I can tell you at my practice, again, first of all, I use the phrase a lot. It starts with a conversation. Let's have a conversation, figure out what's important to you. Because no, we don't have to specify specific items unless you want to specify specific items. I always tell my clients an estate plan can be as specific or as general as you want it to be. It's really up to you. You could just say 50-50 down the middle, boom, 2 kids, done. And I'd say overwhelming majority of my clients do have that easy of an estate plan. Right. Or if they do have specific items, it'll be that. A real common one is I have a lot of farming clients. They want the land to go to the kids who farm. Okay, well, we could put that as a special carve out. Or they have a family cabin and they want to make sure it stays in the family. So we have buyouts, right of first refusal to purchase, things like that. But again, as far as specifying specific items, unless you want it to go to a particular person, most people just want it to go generally in the pot.
Right.
Where a life insurance policy goes is usually irrelevant because the life insurance policy is the same as the checking account, is the same as the brokerage account. It's just money. It's going to be divided up as you see fit. Now, there are some exceptions to that too. I mean, I have some clients who, I had one client who was he did something with stocks. I can't remember exactly what he did. Maybe he was a financial advisor. I don't know. But he had a particular account with his granddaughter that every year they set up and they invested money and did that. So, yeah, that account he wanted going to his granddaughter, but that was different. That was something that was uniquely set up for that specific situation. So again, as a general rule, people will want to make sure that it just gets divided evenly. And again, if there are particular items of personal property, and they don't even have to be large items. I mean, a lot of people just think like cars and boats and guns. That guns is a real common one. But it could be something as simple as, the old grandfather clock. One of the kids really liked that grandfather clock. You want to make sure they get it. Or could even be a cash thing. The example I give is, the 12-year-old boy next door who always shovels the driveway without us asking. We're going to leave him a couple $100. Whatever the case is. You can certainly specify those things, but that is definitely the exception and not the rule.
Is there a level of, and I know this is going to sound like maybe an odd question, but a right of refusal if, let's say hypothetically, I'm like, The neighbor down the road, they're really great and awesome, and I love them, and they've always loved my classic car in the driveway. When I pass, I'm giving it to them,
Yes.
and they go, I don't want that.
Yes, it's called a disclaimer. Yeah, they can disclaim anything they want. Nobody's required to take anything. But as you said, that generally doesn't happen. Most
Right.
people are willing to take things that they receive. But yes, Wisconsin does allow a beneficiary to disclaim their interest in a property for whatever reason.
Now, in the case of something like that, does that then, like, do you have to have a follow-up?
No, it would revert back to the overall distribution. In other words, if you offered it to Joe the neighbor and Joe the neighbor turns it down, then it goes back into the pot. Unless you have a specific provision in your will or trust that says if Joe the neighbor turns it down, then it goes to Betty the other neighbor, whatever the case is. That would be the only way you'd get around that. Otherwise, it would just go back in the pot.
Now, one other thing I hear sometimes is people saying, "Well, I don't want my parents to do this because I'm afraid that they're going to put stipulations like, oh, the house goes to the oldest in the understanding that they never sell it."
Right.
Like,
Well, see, that's the thing. We can't really direct the money from beyond the grave. So I always tell my clients, and it is our wish that that these people never sell it. But yeah, again, I would look at that on the part of the hypothetical child in that situation is awfully selfish. Mom and dad need to have this thing done. Mom and dad should be able to express their wishes as to where they want certain things to go. So yeah, I'm sure there is some coercion among adult children, and that happens in my practice. I see that. But I always try to emphasize to my clients, this is your document. You want to get your kids' input, fine. But at the end of the day, this is your document. You've earned this money. You've worked hard for this money. You have earned the right to determine where it goes upon your passing, regardless of what Junior over there says.
that makes a lot of sense. I want to circle back because we talked a little bit about the power of attorney thing, and we talk about capacity. We talk about coercion and things of the sort. Could there be an instance where 18, 19-year-old comes in with mom and dad are like, hey, we want to be the power of attorney, we want to sign this, and the kid's like, I don't really want them to know this. Like,
Absolutely. And I have to go off what the kids say. It doesn't matter who's paying the bill, because a lot of parents are like, oh, I'll just pay the bill. And I tell them, I don't care who pays the bill. Junior's still my client.
Right.
If Junior's not comfortable signing these documents, we're not signing these documents.
and that lends to the idea that the power of attorney is for the person who's giving the power.
That's right.
It's their document.
It's their body.
Not the people who's getting it.
Correct. That's exactly right. It's their body. It's their choices. All that other stuff. It goes to that person who is giving the authority to say, if something happens to me, I want these people making these choices.
That's really good to know. And you learn a little bit of something new every day, and that's one of those things that I guess I hadn't figured out in my head yet.
You bet.
But that does make a lot of sense. And I know myself, several young adults, 17, 18, who maybe they're ready to be kind of doing their own thing, and having their parents in control of stuff is a big thing for them.
You bet.
We got a few minutes left in the show, so what I'd like to do is kind of wrap it up a little bit in a bow here. Let's talk about how people get a hold of you to have those initial conversations and discussions, and a little bit about different ways that they can find more information.
Yeah, absolutely. So the best way to get a hold of me is just by phone. I may be a millennial, but phone is always the best way to go for me. Reach out by phone, 262-347-3444. Again, 262-347-3444. I do have 4 offices. For most people listening or watching, the Beaver Dam office that Sandy and Matt generously let me use. Mm-hmm. It's probably going to be the closest location. But if you want to take a little bit of a field trip, my main office is in Saukville. I also have offices in Germantown and West Bend. If you do call, please mention you saw me on Daily Dodge or heard me on WBEV. 20% discount if you heard about me that way. But always a free initial consultation. And if it doesn't work to go to one of my offices, I do offer phone consultations. I offer Zoom calls, and I can even make in-house calls as well. So again, my goal is to make sure people have as few obstacles as possible when it comes to making that first meeting. Again, 262-347-3444. That's good for all of my offices. Call that number anytime. You'll get a call back within the next business day. So again, 262-347-3444.
And Rob, I can't say enough for the work that you do. And of course, I know you got some hardworking paralegals on your team who really kind of kick butt and help make stuff happen for you as well. So great group you got there.
Yeah, they're the best.
And of course, this is unfortunately going to do it for today's show. Hopefully the next time we're talking, we'll be a little bit into the postseason for the Brewers, right? I think.
Hopefully postseason. Hopefully a lot lower temperatures too. This mid high 70s stuff is making me melt. I don't like it.
Yeah, I'm ready for the crisp fall weather as well. Some crunchy leaves and some end of season stuff.
Absolutely.
But thank you again for coming on. This has been a paid program. The advice and opinions expressed on the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands.